2023 CR 5714W, State of Texas versus Jonathan Nicholas. Where's the prosecutor? Thank you. All right, court is calling 2023 CR 5714W, State of Texas versus Jonathan Ryan Nicholas. Can I have parties announced for the record for the state?
Jordan Brown, state.
And for the defense?
Alex Scharf, ready.
All right, if you all are behind the court reporter, there's no talking when we're on the record because it makes it difficult for the court reporter to hear. And one thing I try to do, if possible, is make everybody's job as easy as possible. So no talking in the box when you're behind the court reporter and we're on the record. All right, counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Nicholas, I'm going to show you what's entitled Waiver Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict?
Yes, Your Honor.
Did you understand your attorney has certain rights, mainly the passage of 2 entire days from the presentation of the information, and also he has 10 days to prepare for trial. Did you understand?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
And counsel, it's the court's understanding that you've been representing Mr. Nicholas for longer than 10 days?
Yes.
And were you aware about these charges for more than 10 days?
Yes, Your Honor.
And have you received the discovery for more than 10 days?
Yes, Judge.
All right. The court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Showing you what's entitled information. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
State, are you proceeding on the information as presented?
Yes, Judge.
Okay. I'm going to show you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with possession of child pornography? That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Nicholas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 10 years in the prison. There are no applications. This will run concurrent with 2018 CR 3520W. The state will take in consideration the following CM numbers: 105406, 105408, 105409, 10510, and there's to be Chapter 62 compliance. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Judge.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Oh, you're not going to make it.
Oh, yes.
Let's get along around.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State, any evidence?
Yes, Judge. State would offer states 1 with attachments.
No objections.
Mr. Nicholas, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review those documents with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, we're back on the record in 2023 CR 5714W. State, is there any other evidence you would like added to the record?
Yes, Judge, just for the clarity of the record, the report filed as an attachment states Exhibit 1. Most of the dates listed on that are March of 2022.
Yes.
However, the indication in the evidence that's provided in discovery is the date that the material was possessed was actually inclusive of the 6th of December 2021 based on evidence obtained and provided in discovery. And that's the date of the information. And I believe the defense will stipulate that the possession also occurred on that date.
Defense does stipulate.
All right, Mr. Nicholas, do you stipulate to that evidence?
Yes, Your Honor.
All right. All right. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client?
No, Your Honor, we just ask that you follow the plea agreement.
All right. The court will find you guilty, sentence you to 10 years in prison. This will run concurrent with 2018 CR 3520W, taking consideration CM 105406, 105408, 105409, 105412. There's to be Chapter 62 registration. There's to be no contact with minors. And the court will give you credit for any time served. Is there anything else from either side with regards to sentencing?
Nothing from the defense, Your Honor.
Nothing from the state, Judge.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not.
In a tense courtroom inside Texas Department of Criminal Justice jurisdiction, Judge Stephanie Boyd finalizes a plea in State of Texas versus Jonathan Ryan Nicholas. Charged with possession of child pornography, a third-degree felony, Nicholas pleads guilty and accepts a 10-year sentence. The punishment includes mandatory registration and strict conditions. But beyond the legal formalities, the judge makes one thing clear: crimes involving exploitation are never victimless. With firm words, she reminds the defendant that every image represents real harm. Justice is not
Psyche, I'm unsure, but you're going to have to not be around children. You understand? At all. Not be on the internet or anything of that nature. Do you understand?
Yes, Your Honor.
And I remember your mother's testimony, and your mother is enabling you. So you're going to have to be an adult. You understand?
Yes, Your Honor.
All right. Good luck to you. Court is calling 2015 CR 12154, State of Texas versus Stephen Allen Salinas. Can I have parties announced for the record for the state?
Travis Banks, the state of Texas.
Defense.
Robert Gear, Your Honor, for defendant Stephen Salinas, and we are ready.
And are you Stephen Salinas?
Yes, ma'am.
All right. I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
I did.
Are you the same Stephen Allen Salinas who was placed on deferred adjudication in 2015 CR 12154 for the offense of continuous violence against family on March 16, 2016 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 2 on or about the 19th day of October 2020 in Bexar County, Texas. The defendant, Stephen Allen Salinas, did then and there illegally use a controlled substance, namely cocaine, in violation of condition number 2.
Just one moment. How do you plead to that? True or not true?
That's true.
State,
The state will waive and abandon the other allegations.
any objection?
No objections from defense, Your Honor.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
That's true.
Do you still wish to plead true?
Yes, ma'am.
All right, the court will find violation of condition number 2 true. Is there an agreement?
Yes, Your Honor. The agreement and recommendation, should Your Honor choose to follow it, is to revoke the defendant's community supervision, to sentence the defendant, to adjudicate the case and sentence the defendant to 2 years in the Texas Department of Corrections, and give him credit for any time he's already served.
All right, why should I sentence him to the minimum? Has he done anything on probation?
Yes, Judge, may it please the court. Defendant was charged with continuing violence. He did attend and complete the BIP course in this matter to address that. There was also some allegations of drug use.
Just 1 second.
Sorry.
All right, you may continue.
Yes, Judge, sorry. In addressing the alleged drug use, he did attend and complete the Bear outpatient program in this matter. Because of these charges, there was also CPS intervention with the.
Why are you crying?
Because I lost my son.
In what way did you lose your son? Did he pass?
No.
All right. All right, so you lost your son because you didn't do what you were supposed to do. These are called consequences.
No.
You may continue.
Yes, Judge, thank you. CPS intervened and he had to take multiple classes in regards to CPS, parenting, counseling, the whole works over there. He also did complete 117 hours of community service in this matter, Judge. The one allegation of drug use was from October of 2020. Judge will look at the back page. From then until he was expired in March, there was a whole page full of negative tests between then and the expiration of his probation. We understand that we're here because he was not a perfect probationer, but we will affront to the court that he did do quite a bit of what he was required to do, including the classes, the community service hours, and tending to the issues made the basis of this case. Thank you.
All right, State, why should I follow this agreement?
Your Honor, I would echo what defense said, because he completed many of the terms on probation, drug treatment, and at the end of his probation, he was providing negative drug tests on his UAs.
All right, probation, is there anything you wish to say?
Your Honor, the case expired in 2021, so we're past the year mark, jurisdiction, and so forth. The recommendation from probation is to revoke or terms unsatisfactory if the balance is made in full.
All right, so you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand and state your name for the record.
That's Steven Salinas.
All right, Mr. Salinas. So what happened with your CPS case?
Well, like,
Were your rights terminated?
yes, ma'am.
And was your son adopted out?
He was.
Is it to people you know or not know?
I mean, it's to her family, but it's hard to see him.
All right. So when's the last time you used before you were taken into custody?
Last time I used,
Mhm.
a long time ago, ma'am.
When is that?
The proceedings continue as Judge Stephanie Boyd shifts from legal procedure to moral reckoning. After sentencing Jonathan Nicholas to a decade in prison, she delivers a powerful warning. Possession, she explains, fuels exploitation and perpetuates abuse. The courtroom falls silent as she addresses the deeper consequences, not just prison time, but lifelong restrictions and public registration. In this moment, the message is unmistakable. Responsibility cannot be avoided, and the impact of such crimes extends far beyond the courtroom
Technician
walls.
for Sun Auto for about 3.5 years, and then the last couple months I've been self-employed as a mobile mechanic.
Okay.
On top of that, I was just about to go to college and everything before I got picked up. And I did check to see if there was a warrant to take care of this, but
I mean, did you think this was just going to go away?
I mean, I didn't know what happened after, just after my PO told me that probation was over, and then when it came time for just for me to get my ID, that's when I was calling in to see if I had a warrant to take care of all this. I would have been here sooner.
All right. And are you still in contact with Savannah Franson?
I haven't spoken to her in years.
All right. Is there any other questions from either side?
Nothing further from defense, Your Honor.
Well, it appears that he completed all of the conditions that were asked of him. It appears that he hasn't picked up any new cases. Am I right?
That is correct, Your Honor.
And the cocaine positive UA is from 2020.
You are correct, Your Honor.
And so we're in 2023 now.
That's correct.
And so is there any suspicion that he has used beyond that 2020 date from either side?
State has no evidence of that.
Judge, from defense, we have no suspicion. I know from chatting with him, he's been employed, gainfully employed. And I would assume that continuously gainful employment would negate the use and the consequences that stem from that, Judge.
All right, this is what the court is going to do. The court is finding violation condition number 2 true. There is to be no contact with Savannah, Savannah, Francine, Francen. And if it wasn't stated before by the previous judge, there's an affirmative finding of family violence. Court will deny the motion and terminate you on set. Is there anything else from either side?
Nothing further from the state, Your Honor.
All right, we can go off the record. You are going to have to make better decisions. You understand?
Yes, ma'am.
When you have an obligation, you can't just think, oh, I'm doing great, so I don't have to answer to the obligations. Part of drug treatment is making amends. And part of making amends is making amends to people that you've entered into contracts with. You understand?
Yes,
The
ma'am.
only reason why I'm terminating you on set because these allegations are from 2020. According to the probation report, it shows that you've done everything that you were supposed to do on probation. Yes, you owe some court fees, but it's not due to restitution. Are we off the record? Okay, I just want to make sure. All right. With regards to your child, you know the people who have your child.
Yeah.
Sometimes in CPS cases, strangers adopt children and you don't know who have them.
I know.
So you need to straighten out your life. I don't know what your relationship is with your in-laws or what's going on, but I do know that sometimes if someone has a child who was with you, right, and they are not the child their parent wanted to be, sometimes the parent blames the person who was with them. So you need to better yourself. And maybe if you get your life together, 100%, they'll let you see your child. You understand?
Yes, ma'am.
All right. Good luck to you.